Starting today, March 30th, 2026, the United States Department of State is checking the social media profiles of visa applicants in 14 new visa categories. Not just H-1B, not just student visas, 14 more. That includes K-1 fiancé visas, religious worker visas, and even visas for victims of human trafficking. If you have a visa interview coming up and your Instagram is set to private, you need to watch this video right now. In the next 14 minutes, I will walk you through 3 things. First, the complete list of all 19 visa types that are now under social media screening, 5 that were already covered, and 14 that were just added today. Second, exactly what consular officers are looking for on your social media, the specific red flags that can get your visa denied. And third, the 8 steps you should take right now to protect your visa application, including the one mistake that can permanently ban you from the United States. I'm Kelly, an immigration analyst. Every fact in this video comes directly from the U.S. Department of State's official announcement published on March 25, 2026, along with analysis from 5 verified immigration law firms. All source links are in the description below. Nothing in this video is speculation. Everything is verified. Social media screening for U.S. visa applicants is not new. Let me walk you through the timeline so you understand what changed today. In May 2019, the Department of State updated the DS-160 visa application form. From that point forward, every single visa applicant was required to list all social media usernames and handles from every platform they had used in the last 5 years. That covers Instagram, Facebook, X, formerly Twitter, TikTok, LinkedIn, Reddit, YouTube, Snapchat, WeChat, VKontakte, and any other platform. That requirement has been in place for 7 years now. But listing your accounts is one thing. Actively screening your content is another. In June 2025, the State Department announced that it would begin conducting active online presence reviews for student and exchange visitor visa applicants. That's F visas, M visas, and J visas. Not just collecting usernames, actually reviewing posts, photos, comments, and activity. In December 2025, that active screening was expanded to H-1B specialty occupation workers and their H-4 dependents. And then, on March 25, 2026, 5 days ago, the State Department announced another expansion. 14 more visa categories. Effective today, March 30th, 2026. The total number of visa categories under active social media screening is now 19. Let me give you the full list. I'm going to put it on screen so you can screenshot this. First, the 5 visa categories that were already under active social media screening before today. F visas, academic students at universities and colleges. M visas, vocational and non-academic students. J visas, exchange visitors, which includes researchers, interns, au pairs, and Fulbright scholars. H-1B visas, specialty occupation workers, and H-4 visas, dependents of H-1B holders. Now, the 14 new categories added today. I'm going to group them so it's easier to understand. Group 1, domestic workers. A3, which covers domestic workers of diplomats. C3, specifically if the role involves domestic work for foreign officials in transit. And G5, domestic workers of international organization employees. These 3 categories have historically faced scrutiny over labor exploitation risks, and the government now wants to screen their online presence as well. Group 2, training and dependents. H-3 visas for trainees in non-employment training programs, and H-4 dependents of H-3 holders, that's spouses and children. Group 3, family and fiancé visas. K-1, the fiancé visa. This is probably the most well-known category on this list. If you watch the show 90 Day Fiancé, this is the visa those couples apply for. K-2, for unmarried children under 21 of K-1 holders. And K-3, for spouses of U.S. citizens who are waiting for immigrant visa processing. Group 4, cultural and religious visas. Q visas for international cultural exchange participants. R1 for religious workers, ministers and people in religious roles, and R2 for dependents of religious workers. Group 5, Special and Humanitarian Visas. S visas for informants and witnesses assisting U.S. law enforcement. T visas for victims of human trafficking, capped at $5,000 per year. And U visas for victims of qualifying crimes like domestic violence, sexual assault, and kidnapping, capped at $10,000 per year. Let me repeat that. The U.S. government is now screening the social media of human trafficking victims and crime victims who are cooperating with law enforcement. That is a significant expansion. Here is the most important part of today's announcement. The Department of State is not just reviewing social media. They are instructing all applicants in these 19 categories to set the privacy settings on all of their social media profiles to public or open. That is a direct quote from the official announcement. Let me say that again. The government is telling you, before your visa interview, to make your Instagram public, make your Facebook public, make your TikTok public, make your X account public, make everything public. This is not optional guidance. This is an instruction from the Department of State. If your profiles are set to private when you walk into your visa interview, it may raise suspicion. It may trigger additional review. It may result in a 2I-21G administrative processing hold, which can delay your visa for weeks or months with no clear timeline. And on your DS-160 application form, you are required to list every social media username and handle from every platform you have used in the last 5 years. That includes accounts you have deleted or deactivated. You must still disclose them. Now let me tell you exactly what consular officers are looking for. The State Department has not published a detailed checklist, but based on official guidance, immigration attorney analysis, and reported denial patterns, here are the 7 categories of red flags. Red flag number 1, national security concerns. Posts that show support for, affiliation with, or sharing of content from organizations on the U.S. terrorist designation list. This includes sharing propaganda, using specific hashtags, or being a member of certain online groups. Red flag number 2, inconsistency with your visa purpose. This is the most common one. If you are applying for a B2 tourist visa, but your social media shows you job hunting in the United States, that's a direct contradiction. If you are on a student visa, but your posts show you working full-time at a business, that's a problem. Red flag number 3, immigration intent mismatch. If you are applying for a temporary visa, any temporary visa, but your posts suggest you intend to permanently stay in the United States, that's a red flag. Posts about buying property, settling down, or never going back home can all trigger this. Red flag number 4, criminal activity. Posts showing involvement in illegal activities, drug use, violence, or any criminal behavior. Even if the activity happened in another country where it might be legal, if it's illegal in the United States, it can be used against you. Red flag number 5, fraudulent information. If your DS-160 says you were in one country on a certain date, but your Instagram geotag shows you were somewhere else, that's a credibility issue. If you claim a certain job but your LinkedIn shows a different one, that's a problem. Red flag number 6, hate speech and violent content. Posts promoting political violence, militant resistance, extremism, or targeted harassment. Red flag number 7, public charge concerns. Posts that suggest you cannot financially support yourself in the United States or that you intend to rely on public benefits. The key principle is this. Consular officers will compare what you wrote on your application with what your social media shows. Any inconsistency between the two will be treated as a credibility issue. Let me clear up 5 myths I'm already seeing online today. Myth number 1. Only H-1B visas are screened. Reality. As of today, 19 visa categories are under active screening. This includes fiancé visas, student visas, religious worker visas, and humanitarian visas. Myth number 2. I can keep my social media private. Reality: no. The Department of State explicitly instructs applicants to set all profiles to public. Keeping them private may trigger additional scrutiny. Myth number 3. I'll just delete my accounts before the interview. Reality: this is the most dangerous mistake you can make. You are still required to disclose deleted accounts on the DS-160. If you delete an account and do not disclose it, that is misrepresentation under Section 212A(6)(c) of the Immigration and Nationality Act. Misrepresentation carries a permanent visa ineligibility bar. Permanent. Not 1 year, not 5 years. Permanent. Myth number 4. They only check Facebook and Instagram. Reality: no. All platforms are covered. Instagram, Facebook, X, TikTok, LinkedIn, Reddit, YouTube, Snapchat, WhatsApp if you have a public profile, WeChat, vContact, and any other platform. Myth number 5. My approved petition means my visa is guaranteed. Reality: no. If your employer filed an I-129 petition for your H-1B, or your fiancé filed an I-129F for your K-1 visa, and USCIS approved it, that approval does not protect you from visa denial at the consulate. Consular officers have independent authority. Social media findings can override petition approval. Let me give you 2 scenarios so you can understand how this works in practice. Scenario 1. Maria is a 28-year-old woman from the Philippines. Her American fiancé filed a K-1 visa petition for her. USCIS approved the I-129F petition. Maria has her consular interview scheduled for next month. She has an Instagram account with 300 posts. Most are photos with her fiancé, travel photos, food photos, nothing unusual. But buried in her posts from 2 years ago are several photos of her working at a friend's restaurant in the United States during a previous tourist visit. She never had work authorization. If the consular officer finds those posts, Maria's K-1 visa could be denied. Not because of the K-1 petition, but because the photos suggest she previously violated her visa status. Scenario 2. Ibrahim is applying for an R1 religious worker visa. His mosque in the United States filed a petition. Everything on paper looks fine. But Ibrahim's Facebook account contains dozens of shared articles and posts from organizations that appear on the U.S. designated list. Ibrahim may not even be aware that these organizations are designated. He was sharing content he agreed with from a religious perspective. But the consular officer flags this during the social media review. Ibrahim's case is placed into 221G administrative processing. No timeline is given. His visa is effectively on hold indefinitely. These are the kinds of situations that are going to become much more common starting today. Immigration attorneys are expecting 4 things as a result of this expansion. Processing times will increase because consular officers now have more content to review per applicant. The number of 221G administrative processing holds will increase as more cases are flagged for further review. Refusal rates will likely increase in marginal cases where there are inconsistencies between the application and the applicant's online presence, and appointment capacity at some consulates may decrease because each interview takes longer. Here is exactly what you should do right now if you have a visa interview coming up. Step 1. Audit every single social media account you have: Instagram, Facebook, X, TikTok, LinkedIn, Reddit, YouTube, Snapchat, WhatsApp, WeChat, everything. Step 2. Set all profiles to public before your interview. The Department of State is instructing you to do this. Step 3. Review and remove or archive any posts that are inconsistent with your visa type. If you're applying for a tourist visa, remove posts about working in the U.S. If you're applying for a temporary visa, remove posts suggesting you plan to stay permanently. Step 4. Do not delete accounts. You must still disclose them on the DS-160. Deleting plus not disclosing equals misrepresentation, which is a permanent bar. Step 5. Prepare your DS-160 carefully. List every username and handle from every platform from the last 5 years, including deleted and deactivated accounts. Step 6. Check your tagged photos and comments. Other people's posts that tag you are also visible to consular officers. Step 7. Avoid posting anything related to violence, extremism, hate speech, or illegal activity from now until after your visa is approved. Step 8. If you have any concerning content or a complex social media history, consult an immigration attorney before your interview. Not after. Before. Let me leave you with 3 things to remember. 19. That's the total number of visa categories now under active social media screening. Public. That's what all your profiles need to be set to before your interview. And permanent. That's how long a misrepresentation ban lasts if you delete accounts and don't disclose them. This is real. This is effective today. And this affects millions of visa applicants worldwide. Now I want to hear from you. Which visa type are you applying for, and have you already set your social media to public? Drop a comment below. I read every single one. If this video helped you understand what just changed, hit subscribe and turn on the bell. I post weekly immigration updates, calm, fact-based, no drama.